Welcome, law students and legal enthusiasts. So, look, if you're studying tort law right now, you already know negligence is literally the backbone of your entire syllabus. But reading the theory and actually applying it to some tricky exam question, yeah, those are two very different beasts. So today, we're diving into this explainer to completely dissect the landmark 1951 House of Lords case, Bolton v. Stone. Basically, this case is the ultimate test of reasonable foreseeability. And by the end of this session, you're going to understand exactly how courts draw that super fine line between a tragic accident and actual legal negligence. It's going to give you the exact tools you need to absolutely crush your tort law exams. Okay, here's our roadmap for today. We're going to start with the cricket ground incident, look at the clash of legal arguments, dive into the House of Lords judgment, see how it shaped modern negligence law, and finish up with your exam-oriented summary. Section 1. The cricket ground incident. Let's set the scene. Miss Stone is simply standing on a public road just outside a cricket ground. Inside, a batsman hits the ball, it sails over the fence and strikes her squarely on the head. Now, for your exam, pay close attention to the geometry here. Miss Stone was exactly 78 yards from the batting crease, and the ground was surrounded by a massive 17-foot fence. And that brings us to the core tension of the case, perfectly illustrated by the number 6. During the trial, evidence showed that a cricket ball had cleared that 17-foot fence only about 6 times in nearly 30 years. Just 6 times in 3 decades. This statistical hook is absolutely everything for your exam analysis because it establishes the extreme rarity of the event. We're not talking about some daily hazard here. We are talking about a total freak occurrence. So, this brings up a huge question. And honestly, it's a trap so many first-year law students fall right into. If someone gets injured, is someone automatically legally at fault? Look, Miss Stone was totally innocent here. She's just standing on a road, right? She suffered a terrible injury, and it's human nature to want to compensate her. But tort law, it isn't just about sympathy. It's about duty and breach. This sets up the whole legal tension of our explainer. Was the cricket club actually negligent for failing to prevent this incredibly rare accident? Moving right along to Section 2, Clash of Legal Arguments. Let's step into the courtroom. Understanding how to argue both sides is exactly what your professors are looking for when they grade your essays. Notice how perfectly these realities contrast. On the plaintiff side, Miss Stone's team argued that the club knew balls could occasionally escape. Since the road was right there and open to the public, there was a completely foreseeable risk of injury. They figured the club should have installed an even higher fence, and failing to do so was straightforward negligence. But then, look at the defendant's side. The cricket club countered that they'd already taken reasonable precautions with that 17-foot fence. They pointed straight at the stats. The occurrence was unbelievably rare, making the injury highly remote. Their core defense: the law requires reasonable care, not the absolute 100% prevention of every conceivable accident. Which brings us to Section 3, the House of Lords judgment. Let's break down exactly how the highest court reached their conclusion, because this is the exact logic you need to replicate on your exam. First off, the House of Lords acknowledged that, yes, a theoretical possibility of the ball leaving the ground existed. They didn't deny physics, but, and this is a big but, they distinguished between what's theoretically possible and what is reasonably probable. They noted the probability of actual injury was incredibly small. Plus, reasonable safety measures, 17-foot fence, were already firmly in place. So they concluded there was no breach of the duty of care. A reasonable person just wouldn't take further extraordinary precautions for such a super low-risk event. All right, grab your highlighters, because here is the ratio Decidendi. For you law students out there, the ratio is the binding legal rule you absolutely must have in your notes. The exact holding here is: a person is not negligent where the risk of harm is so slight that a reasonable person would not consider it necessary to take further precautions. Negligence relies on reasonable foreseeability and the likelihood of harm, not just the mere fact that a tragic accident happened. Write that down, underline it, start for your exams. Section 4, Shaping Modern Negligence Law. Okay, beyond that binding ratio, we have to talk about the obiter dicta. These are the judge's observations that, while not strictly binding, are massively persuasive. The judges pointed out that courts have to balance the likelihood of injury against the burden of taking precautions. Basically, the standard of care varies directly with the probability of harm. If the risk is high, standard of care is high. But if the risk is astronomically low, the law doesn't expect defendants to literally bankrupt themselves trying to eliminate every improbable hazard. These observations were a total game changer, giving birth to the modern risk versus burden calculus that courts all over the world use today. Let's synthesize all of this. Here are the hard and fast legal principles you need to know. 1. Reasonable foreseeability is essential for negligence. 2. A super low probability of harm means no extra precautions are required. 3. The standard of care depends directly on the likelihood of injury. 4. And seriously, if you only remember one thing, make it this one. The law requires reasonable care, not absolute safety. And 5. An accident alone, no matter how awful, just doesn't automatically prove negligence. And finally, Section 5, your exam-oriented summary. We've covered a lot of theory, so let's condense it into your ultimate study guide. You might even want to screenshot this. You've got your metadata, Bolton v. Stone. The citation, 1951 AC 850 in the House of Lords. Area of law, torts and negligence, obviously. The key doctrines to absolutely name-drop in your essay are reasonable foreseeability and standard of care. And the final decision, plaintiff's claim dismissed. Having this structure totally memorized is going to save you crucial minutes when you're outlining your IRAC, issue, rule, application, conclusion, during a timed exam. Just to firmly cement this in your mind, let's hit that core legal principle one last time. Negligence depends on reasonable foreseeability and the probability of harm. It is essentially a giant balancing act. If you can elegantly explain that balancing act in your exam answers, you're showing your professor that you truly grasp the real mechanics of tort law, not just robotically reciting facts. Now, if you're aiming for that A grade, you've got to show some critical thinking. That means acknowledging the counter-arguments. And there is definitely valid criticism of this case. A lot of legal scholars argue the decision placed way too much emphasis on the low probability of harm and kind of glossed over the highly serious consequences of a head injury. Some argue that, hey, because a cricket ball to the head is so dangerous, stricter precautions should have been demanded, regardless of how rarely balls actually escape the ground. Slipping this criticism into your essay shows a really sophisticated, well-rounded grasp of the law. So I want to leave you with a slightly provocative thought to mull over before your exam. We're talking about a ruling from way back in 1951. If this exact same freak accident happened today, would a 21st century court view it the same way? Would modern safety standards, advanced netting technology, and, let's face it, a much more litigious society require stricter preventive measures today? Think about how the standard of reasonable care evolves with time and technology. Keep that in mind as you study. Thanks for hanging out for this explainer, and good luck absolutely crushing those tort law exams.